office is directed to trace the
Pardon me, Milord.
trace the memo and place it on record. Yes.
All are two people.
Yes. 29.
In item 29, my lord, I'm appearing for respondent 3, 5 and 6. We have filed a status report complying with the directions of this honorable court. Along with the status report, we filed the seizure notice, my lord. The temple which is, the disputed temple is now seized under section 461A of GHMC Act.
Why?
It was an encroachment, my lord. The temple was, they have constructed an unauthorized structure.
Unauthorized construction has been accepted. And in that, they have been constructed.
Your grievance stands redressed.
No, Milord, that construction is there, that has to be demolished.
So then what do you do next?
That has to be demolished.
It's a very sensitive issue, my lord. We have seized that property under 461A. After
Waiting
issuing,
for directions of this.
yes, with your lordships. Page number 10, your lordship will file the seizure.
You, Mr. C,
It has to be,
the report placed by counsel for GHMC stating that the temple in question was being constructed unauthorizedly and the same has been seized by
Yes, respondent 3, 5 and 6.
in exercise of powers under
461A of GHMC Act.
right? The aforesaid status is taken on record. List after 3 weeks.
it has to be demolished unless there is a direction.
We need to hear it's 1:35. See the time. That's why we have said after 3 weeks.
Your lordship,
They have made some progress, right?
2 weeks may be created. 2 weeks.
your lordship, item number
How
30.
many are authorized structures in the state? Find out how many.
Your lordship, item number 30, your lordship, representing for respondent number 2, 3, 4, 6 and 7.
2, 3, 4, 6,
6 and
7.
7.
Case 1 is
3
granted.
weeks time for counter hearing.
4 weeks time to file count.
Oh, bless me.
May I please, your lordship? I am representing the petitioners.
This matter may not, affidavit is served on me, no?
We have passed an order on
Yes, my
11.
lordship.
Why it has come now?
Last occasion, my lord, your lordship directed the Lake Protection Committee.
Huh?
Lake Protection Committee to
Where is the council is not there?
I am appealing for the Lake Protection Committee, my lords. I filed
Right,
an
but you are
affidavit.
the council not smiling. The Lake Protection Committee council used to smile. That's how we remember. Correct?
Yes, my lords.
He is not smiling. Why?
That is my senior.
He was your senior. So you should. Where is that?
I filed affidavit 7598720.
No, Mr.
Yes,
Notifying the buffer zone for existing water bodies. Where is the notification?
I filed an affidavit.
Have you done it? Not done it?
No, we have done it, my lordship. The effort is being made. Your lordship will see. I have given a tabular form where with regard to lakes, my lords, the identification of lakes is a continuous process, my lords. Lordship will see kindly, lordship take the affidavit.
No, are you required? Mr. Again, you have started arguing. We are asking you simple thing. Have you notified the buffer zone of existing water bodies in the limits of HMDA?
About
The answer is yes or no.
yes, to the extent of 230 lakes, my lords.
Then say so.
Yes.
You are saying I am giving chart and all that. What chart?
Sorry.
Chart of non-compliance, right?
No.
Then say so. First sentence should be that I have complied with the directions contained partially. There are so many lakes. Out of them, this much I have notified. How many lakes in HMDA limits?
As on today, my lord, there are about 3,532 lakes.
3,500
32 lakes. And there's
in HMDA limits. So it has to be preserved at all costs, right?
Yes.
So then how many have you notified?
Preliminary notification has been done for 2497 minutes.
What preliminary notification? It's a land acquisition thing, preliminary notification, final notification. Under which law preliminary notification have you done?
The Lake Protection Committee was constituted through a.
We are not asking about constitution. You said I have issued preliminary notification. Under which provision of the act?
CO 157 minutes. GOMS.
There is no provision of law.
No.
There is no Lake Authorities Act or Tank Development Act in Karnataka, in Hyderabad.
May I make a submission, my lordship? May I make a?
Make a submission only
Yes.
to assist, not to
Yes,
complicate.
my lordship. In fact,
Which provision preliminary notification?
GOMS number 157, which has been issued basis on the orders of this Honorable High Court, a Lake Protection Committee has been formed. GHMC Commission.
It's not an order from the court. Lake Protection Committee constituted.
Lake Protection Committee has been formed by GOMS number 157 dated 6/4/2020
157.
in compliance with
Just
the
a
order.
minute. We are writing, Mr.
Much of, sorry.
It's very easy to,
My apologies.
we are not stenographers, right? So that we
My
can.
apologies.
So GOMS number 157 of 20.
Yes, my lordship. 2010.
2010, 2020 you said.
6/4/2010. 6th April 2010, my lordship.
So GOMS is 157 of 2010.
Yes, my lordship.
That Lake
This is-
Committee constituted.
Yes, this
Now
is
under
from-
which provision they have issued a preliminary night
Absolutely.
notification?
In fact, my lordship, if we see this GOMS number 157, it only states about listing of lakes. In fact, they have
So that's
irrigation.
why you understand that it's a preliminary notification is incorrect.
Yes, my lordship. It is incorrect. In fact, the irrigation department has got the lake memoirs. They have every data of the lakes.
So this thing, buffer zone is provided no in respect of each
Yes, my
listing
lordship.
lake, and that is Mantri developers Supreme Court.
Absolutely, my lordship.
Yes,
Yes, my
Mantri developers, Mantri tech zone. So this all submission that it's a preliminary notification and then inviting people to meet them alone
Yes,
and
ma'am.
then dropping in final notification
Yes, my
from lakes, this all.
It is all about
Correct,
encouraging. Yes, absolutely, my lordship.
Ah.
In fact, in Mantri's notification, I was also there in
Mr. Rich,
Bangalore.
which provision of law preliminary notification of lake inviting people come and meet our officers privately?
No.
Huh?
My lordship,
This is all we understand, Mr. These tactics. Don't.
no,
Which authority? You will file an affidavit stating that under which authority you have issued a preliminary notification.
Lordship may kindly see.
When there was a direction to notify the buffer zone. Well, how come you have issued a preliminary notification? This is violation of the order. Who heads the committee?
Commissioner GHMC.
Commissioner? What?
GHMC.
Huh?
GHMC.
Member convener is the person who is
Huh?
who's filed the affidavit, my lords. Environment is part of the committee, my lords.
No, Commissioner GHMC heads the committee. He is responsible.
R9 is the chairman of the Lake
Which-
Protection Committee.
Thrice we told you, asked you, you are not answering. That which provision of law he has issued a preliminary notification when there is an order passed by this court which was attended to by your senior, but you should notify the buffer zone of all the existing lakes. What preliminary notification? This is not Land Acquisition Act.
My lordship,
1894 notification under section 4, inviting objection, then declaration under section 6, and thereafter you will pass an award.
my lordship, as per GOMS 157, my lords. Lordship may kindly take.
Mr. Reed, does it provide for GOMHS?
I'll
Excellent. You don't know. We are asking him, does it provide for preliminary notification?
No, my lords. The language is absolutely
Well,
clear.
I'll
Listing.
Where is your notification?
file an affidavit to
No,
the.
where is your notification? Preliminary notification. Which page?
There are about, I have not filed preliminary, there are about 2,497 lakes, my lords.
I know, how are you telling us that preliminary notification? Mr. This, you have to issue a notification indicating the buffer zone of lakes. How can you, what is preliminary?
My lordship, I'll file an affidavit to the extent explaining everything, my lordship. Lordship may grant me some time.
Explaining everything? What? I will explain. He will appear and explain. Which under, we will ask him, Mantri Tech Zone, is he not entitled to notify? And what is this preliminary instead of you explaining because you don't understand. But what is preliminary notification?
I will file an affidavit to the.
No.
Kindly,
You understand. Did you even understand what are you submitting?
My lordship, preliminary, may I?
You said yes or no?
My lordship, GO 157, my lords, we have acted in accordance with GO 157.
Nonsense.
Notification department. It is all notified. Yeah. These are all minor or major irrigation tax. They were all under these times, there was the cultivation that was done since maybe city has developed in last 20 years, but all these are agriculture tax.
Yes.
Okay. Now these are all minor irrigation tanks in the respective this thing covered by your Panchayat Raj department and the irrigation department. Basically, it is, they are all will be under irrigation department. In fact, I gave you a clue also. Go to one book called The Lakes of City, Hyderabad. 100 Lakes of City or the title where you get everything, FTL, buffer zone, everything. Your HMDA authorities are not talking to irrigation department.
My lordship,
If you get to ask them what did you do geotagging? If you are saying you have not, then how did you do geotagging of all the lakes? You claim on the other hand you have done geotagging for all the lakes. How did you do it? Without knowing the buffer zone, without knowing FTL? That's why I'm saying there is a earlier all these tanks, they're all part of Rangareddy or other village.
Asking to, you will asking to produce an interpretation. You can tell it to what that should make direction of the company. We are giving you benefit of doubt. You, on the next date, you filed an affidavit saying that the directions issued by us on
20.
on this thing,
27 July.
27 have been complied with. In case not complied, it's a contempt. The consequences will follow. Perhaps you are not realizing what you are saying. Right? There is nothing concept preliminary notification. But still, for your inexperience and youth, we don't want to punish Commissioner GMC. Therefore, we are giving you an opportunity to explain by way of an affidavit how this order directions have been complied with and how many lakes you have notified. We were recording your oral submissions. Mark the presence. This code by an order dated 27 July 2023.
Public holidays, my lords.
They have to work extra time.
My lordship, my humble,
One more thing. Please, one more thing.
The order is passed, it is open to challenge in SLP.
my lordship, there is.
Make them work. It's a question of future generation, not for us. We don't go for voting in the lakes. What you have been doing since 2010, they will land in trouble, mister. As an officer of the court, you must realize, don't make an attempt all the time to protect the persons who are inefficient and don't want to work and want to enjoy holidays. You tell them, it's as an officer of the court, your duty is to bring the order to their notice. If they don't comply, why are you pleading like a beggar on their behalf? They will face the music, right? You say that despite my instruction, they have not complied with. We will deal with it.
My lords,
We don't need your assistance. Right?
my lords,
If they don't listen to you, don't you communicate? You do your duty by communicating that I have made a prayer that it will be taken up next year on 24th December. Court did not agree. Tell them I tried my best that I wanted 8 months time so that you can go home early and enjoy your life, but court refused. Tell them, should we record it? Then this is a public cause. Don't fight it like a personal interest litigation. This is for future generations to come. Repeatedly, we are telling. We don't go for voting. We don't have time. I haven't seen any water body in Hyderabad. Oh, see, the council has come. You should have come early. He's facing the heat, saying for adjournment. He will tell you the order we have passed. Next.
my lords, there is a second order also in that. There are two directions. The second direction is GHMC commissioner has
Coming up.
Both should come together.
GHMC, what
They filed their counter.
you know what your friend is trying to tell. Not do. Otherwise, you will also.
affidavit undertaking has to be given by GHMC commissioner for unauthorized constructions, which has not been done.
You understand, right? Better comply, otherwise
Items 32 to 35.
he will be here then in that case.
Much obliged.
What, 32, 35?
Declaration of progression.
Right, please. And up here. Also, counter has been filed.
Counter filed.
You have pleadings are complete.
Yes, Your Honor.
Pleadings in the case are complete. Petition is admitted for you.
Item 36 and 37 D. Narendra Nayak, Additional Advocate General.
Ah, yes. Yes, Mr. Pleadings are complete.
Pleadings are complete.
All right. What is the validity of rule minor mineral?
Rules are under challenge.
Last date it submitted.
Additional.
All right, so
Moved on.
yes. So we'll admit it.
Any short date notice?
What short
No, that means lots of it posted today for
No.
nothing. Because
synopsis, 2 pages, facts, submissions, case law. 2 pages if you want. Every case can't be heard in motion hearing. You will agree. There is no justification. Yesterday, 2005 matter writ appeal we reserved. The persons have retired. One of them terminated, serving on 1,500 rupees per month. They are claiming UGC pay scales. Every cause is important. What's the justification? Your client is a industry, can afford this thing, litigation.
the rules have been amended, my lord, without jurisdiction, without legislative competence.
In order to enable us to take up the matter, give a brief note on facts, submission thereafter, case law. And if you want it, we are telling you, giving hint to everybody, whosoever wants to, this thing want us, we are willing to decide cases in motion stage, but not that we will take up this case. You will argue for 1.5 hours, he will argue for 3 hours, then you will reply for 1 hour. 10 minutes flat. If you want to conclude, then if you have a confidence in your case, then file an application for urgent hearing, admitted for hearing. We'll consider. And you say that I undertake to conclude within 10 minutes, then only we will allow.
Definitely.
Ah, yes.
Item 38, Aisha Sabah, baby for.
Yes,
I filed my counter in this matter.
counter. Yes, madam.
The matter pertains to encounter lordship, two
Encounter.
days back, they filed counter lordship. My senior.
Encounter or counter? Counter in
2 days back, they filed counter lordship.
counter. All right. We thought a matter pertains to encounter.
Lordship, matter pertains to encounter.
Encounter. So when we heard correctly,
That's why I said it is counter in encounter.
counter in encounter.
Yes, my lord, we filed our counter.
So then, madam, you want to this thing?
Lordship, senior will argue this matter lordship. Grant weeks of time.
Oh, where is the order like of remand by Honorable Supreme Court? Mr. 38.
This is some other matter, madam, the PUCL matter, Bombay matter, not this court. In this court, where in this case, where is the remand order from the Honorable Supreme Court?
Lordship,
No, no, why we are asking you? Because the under the heading it is listed on remand from Supreme Court. So we want to see what is the order of remand. Ah, Mr. Yes, what happened to your civil appeal 8082 of 22?
It's pulled off, my lords.
When? That's equal.
I'll,
There must be, in that order, there must be a direction or something.
locate it, my lord. But the challenge to the
Learned counsel for the parties pray for adjournment. Yes, madam. Huh? Which case, madam? Out of list. This very bench. Hmm. All right, next Friday. Which one? This
May it please your lordships.
133.
May it please your lordships. But I am appearing for the eighth respondent in the first writ petition. That may not survive now. But the complaint was, I am appearing for the industry, matter arises under the pollution laws. I appear for the industry, my lord. The complaint in the writ petition was that I was operating without permission and the very existence of the industry in that area will hazardous is what their contention. But however, my lord, pursuant to the application made by the petition in 2016 for grant of renewal of lease license, my lord, the industry has been closed, not functioning as on today. The second writ petition, my lord,
Renewal has not been granted to you.
that was rejected in 19/7/23.
Who
Only on,
appears for petitioner?
in the first writ petition. I am for the second. I am in the
No,
second.
no, you first petitioner, you are the petitioner.
I am the respondent number 8.
We want to know from the petitioner. Obviously, you will say that it is infructuous. Nobody,
Respondent number 8.
none for the petitioner. Hmm.
May I narrate few facts, my lord?
No, no. Here. Ah. So you are not carrying out any mining
Yes,
operations?
my lord. Even the
This renewal has not been granted?
yes.
All right.
The second
None,
writ petition.
fine. We'll first deal with it, come to
Yes,
second
I'm
later.
good. I'm good.
Mark the presence, none
I'm good.
for the petitioner. Mark their presence for learned counsel for Is here? Not here. Okay. What do we say? None. None for the petitioner, right? Ah. What?
My
What?
lord, insofar as the second petition is concerned, my lord,
Ah.
by an order dated 19/7/23, my lord, the State Environmental Impact Assessment Authority rejects the permission only on the ground that the Google Maps show the entire land given on lease for mining is covered under the forest, reserve forest. But the forest department themselves have granted clearance, my lord, which was placed before the authority also. Then, my lord, on 19/7 itself, we made an application saying that this area, my lord, 20 years ago, the license was granted and this is a renewal, and the authorities have given various, all authorities have given permission.
So, Mr. In previous, this is what we have disposed of his petition, and now you are challenging that.
That's why I wanted to narrate the facts, my lord. I took leave of the court to narrate the facts.
Ah.
Because both are connected this
Not
way.
carrying out any so and so, and further submits that he shall carry out quarrying operations only if the permission is. So they have to respond, right?
Respond, my lord. Last occasion they had taken back.
Google Map. So, you want to file, don't want to file.
We want to file counter.
How much? Again, this is not by invitation. Repeatedly, we are telling you.
No,
We shouldn't distribute print invitation cards and ask whether. Don't want to file. We will say all of them standing, not saying anything. And therefore petition is allowed. Averments made in the petition are taken to be this thing corrected in the absence of any counter. Therefore petition allowed.
My learned friend is appearing for the authority which has passed the impugned order, my respondent number 4, State Environmental Impact Assessment Authority. I would like to bring to my lord's notice that the time period of the authority has lapsed, my lord. So I need to take instructions for constitution of new authority, my lord. The members, the tenure, my lord, has expired. So I need to take instructions regarding that as well, my lord. I need to bring it to the notice of my lord that the authority does not exist anymore.
So-
as it stands.
Who wants to file a counter? Nobody.
No,
Learned counsel for respondent number 4. Learned counsel for respondent number 4.
My lord.
Prays for adjournment to enable him to
Take instructions, my lord.
seek instructions about the existence of state environmental impact assessment. How does it, supposing it consists of A, B, and C? Now, B, A, E, and F are members. That you will say that the authority does not exist.
I'm so sorry, my lord. I stand corrected, my
You
lord.
don't, Mr. Most of the times you are not clear about what you are saying.
I'm so sorry, my lord.
Just now you saw that the pre-lunch period, one council said that we have issued a preliminary notification. He did not realize what is preliminary notification, notifying the this thing, buffer zone of tanks. We asked him which provision. He said preliminary notification. This is what you are doing.
I'm so
You
sorry, my
don't
lord.
understand what you are saying. Merely because it is reconstituted, that doesn't mean that. Please advise the young man, Mr. Counsel, you have some experience. Please advise him that he should make such submissions, right? Tell him, offer him over a cup of coffee, tell him it's a weekend also that he shouldn't make such submissions before the courts and waste our time. Which is precious. And in any case, the whole thing is unproductive. Why? Because it's being adjourned. It's not that we are devoting time to do something. These people don't say how much time they want. It's still 5 minutes. So despite this is not invitation. You know, Mr. You appear before.
Yes, ma'am.
Why are you not saying? I appear for R3, 2 weeks time, 3 weeks time.
Yes.
Not saying.
I'm concerned with the first response.
You say I don't want to. I'm not a contesting respondent.
No,
I don't want to file.
I'm the contesting, not I seek the 2 weeks time.
I means no, again you are not telling.
Respondent number 1, state, principal secretary.
Simple, right?
Not
Again,
two-
process of.
I seek 2 weeks.
No, we will not do it, Mr. Repeatedly, it has been over 10 days, now 3 weeks. Now, bar knows me sufficiently good enough. If you don't understand the judge, then you are to be blamed. We are telling you repeatedly, if you stand up looking at us, we will say that they have stood up without mentioning a word, and we will proceed. You know that you have not filed counter.
Yes.
You should, first sentence, it should have been long back over. We are giving sermons to you, troubling our vocal cords for nothing.
No.
And you don't
My lord.
approve. No, now what we have done earlier, we have modified our orders, but we will now not modify. That they stand up, say nothing, and the order will follow. He is happy if you don't file counter. Delete.
I sincerely seek.
Young man, understand. It's study. Let this weekend be an occasion to learn something more about that mere change of members does not. By mere change of members, authority does not cease to exist. It is constituted under an enactment, rules, and that rules are required to repeal the. You cannot make a statement. Supposing if we record this and send it to the authority that your council is making such submissions, what they will feel.
So sorry, much
That he is so learned that he is saying that authority itself was dissolved. What is this? Learned Council for Respondents. May 5. Huh? Yeah. Objection to file.
In this,
We'll grant
this-
4 weeks. Why?
my lord, in this both the matters,
135.
yes, 135 and 136.
Yes.
My name is not being printed even though the honorable court time and again directing the registry to to print my name. Due to
Is
which
there
I am
an order?
unable to follow the.
Yeah.
Yes, I have given
What's
the
that?
name.
I will see just now. Which order, Mr. What's your name? You are appearing for petitioner?
Petitioners.
Huh?
Petitioner.
What's your name? His
I have
name?
given the slip. Mirza Nisar Ahmed Beg. I have given slip.
Office is directed to reflect the name of Mr. So and so as the last. Proposed LRs of which petitioner? Which appellant? Several or one? So office that reflect Mr.
clarify.
name of so and so as counsel for appellant, LRs of diseased appellant.
Appellants, my lord.
No, counsel for appellants.
Appellant.
Okay. Then Mr. You, madam, you also appear, both of you appear. What's right? Your name, please give. So and so learned counsel appearing for proposed LRs of diseased appellant. Place for is granted. 6 also same order, 36.
8 with lordships. I filed this contempt case basing upon the orders of this honorable court dated 2/1/2023, my lord. R1 and R2 filed SLP
Oh,
before
this-
the honorable Supreme Court, my lord. They have obtained stay, my lord. These are the copy, my lord. In this matter, my lord, please, I may be permitted one submission, my lord. As per this honorable court has not passed.
1 minute. You know the order passed on 28 July.
2/1/2023, my lord.
You
I have filed this contempt case.
No, you are Mr. Srinivas Sharma.
Yes, my lord.
We need to tell you what order has been passed on 28 July 23 in your presence.
No, because of certified copy order has to be filed with application SR number 68.
Correct, 2/1/23.
Yes, my lord.
You have not filed.
This honorable court has not passed a separate order in the stay application. That was passed in the bind case itself. I have filed page number 16 to 19. Once again, obliging the orders of this honorable, I filed along with the memo, my lord.
This is content. It means you principle of this. So if it is.
Another submission, obliging the orders of this honorable court, I have filed certified copy also, my lord. In this matter, the R1, R2 filed is SLP before the honorable Supreme Court. Honorable Supreme Court has granted further proceedings remain stayed. I have filed in material papers. I have also just circulated the copies.
On the question of admission, this petition has been filed for non-compliance of the order. Order.
I also filed another certified copy, my lord. Problem.
Notice of this petition has been issued. What? Mr. Sharma, it is issued. Yes, yes.
Lords, in this complete office objections, my lord, but office wants direction from this court to number it, that's what the registrar has informed us.
Office objections, you sought time.
I complained, my lords.
Complied.
I complained.
What have you done?
Because last time Lordship did not say after compliance, number it, they are again.
Amended cost title in civil suit 13 of 1958. Where is amended cost title?
That is not available in the court registry, my lords.
How can?
It's not available in that. Not this.
How can this be?
I gave letter to register also, my lords.
You said that I asked.
Just now you said you have complied the objections.
Yes, that, what objection they
And
are.
how can you say that, you should say that I am not in a position to comply because copy is not
I'm
available.
sorry.
You are saying that I have complied. Mister, you are an officer of the court. When you make a statement before this court, we believe it. Don't mislead.
No, my lord, sorry.
Don't. What should you have said? That, sir, this I am unable to comply with first objection because cost title is not available in the registry.
I gave letter to registry also, my lord, to furnish.
Then why did you say that I have complied?
Other objections, I complied, only this objection, I don't know what they have written that. Other objections, all I complied with, last time what objection they were given, I complied with.
Did you effect service on all the parties?
Lord,
That was the second objection, right? Service
That-
to
that-
the effect.
I paid Bata, my lords, I served copies on the commissioner receivers, I paid Bata to all the respondents, my lords.
Where is the copy? Where is?
But that,
Filed it.
that exact, that objection not taken now. I filed, my lords. Bata I paid to all the respondents. It will be written in words in that.
Where is proof of service to respondents?
My lord,
How Mr. you are saying that?
Bata I paid, my lords, to all the respondents.
What is paid?
My lord, postal charges, my lord, I paid. Process fee, my lord, I paid.
Process fee.
I paid, my lord, to all the respondents.
No. The moment you pay, the presumption arises that they have been served. You are not required to file this thing, a proof of service, right?
But unless court orders notice, my lords, I cannot take notices to them because they're
Are
individual.
you not, under the rules of this court, are you not required to serve an advance copy? That's how these people appear. Most of the
Only, my lord,
cases I've been noticing that even private respondents appear. We ask them how you are appearing. We have yet to admit the intra-court appeal. He says on advance notice. That means there has to be a rule in place
Lord,
which
the
permits you, which
advocate,
requires you to serve an advance copy.
but parties are represented, advocate commissioner, receiver, but they're representing the parties, my lords.
No,
Receiver and
Mr.
commissioner.
Thing is simple. If you don't want to comply, fine. The consequences will ensue. Your destination is northwards. Proceed.
Because we filed part of.
If you don't want to comply, say so. I don't want to comply. We will pass an order.
Amended caution, my lords, I gave letter to register, lords, may kindly have a look at it, my lords.
Mister, we had last time, please understand, on 28/7, we had granted you, you had prayed for 2 weeks time to
Yes, my lord.
comply.
Yes, my lords.
Now you are under an obligation to tell us that I have complied.
My lord,
First instance, this all being noticed, right? We remember, right? First instance, you said, I have complied with. That on verification of record, that statement is found to be incorrect. Now your second submission is that cost title of civil suit is not available in the record. Again, if that is found, you again will be guilty of making a second incorrect submission
again,
before a division bench.
Lord-
Third is, you are not prepared to file proof of service. And you are arguing on office objection. What, Mr.?
my lord, individual person, my lord, court orders notice, my lord, will take notice, my lords.
Tell him.
But Bata, my lord, I paid, we usually pay Bata to all the respondents, my lord, that way.
That doesn't mean
Process fee.
it is understandable that you pray for time to file proof of service. That we can grant further time. But don't say that moment I pay Bata or whatever, they are deemed to have been served.
Lord,
In some other case, where Mr. Senior Counsel will appear, the moment he will pay charges, we will take, next day we will take, you are served and pass an order against you. If you are a respondent in that petition, right? What is this?
May I just say this, Spirit? As far as the writ proceeding rules
You are
of this court,
yes.
I am not in this case.
Yes.
As far as the writ proceeding rules 1977 of this court
Yes.
are concerned,
Yes.
the service in the writ petition is deemed to be service in the writ appeal, that is intra-court appeal also.
Oh.
That is the reason why in the intra-court appeal, Malad, even without filing caveat and Vakalatnama, the successful party before the learned single judge take
They
notice
appear.
and oppose. They appear. But as far as
They
civil
are,
matters,
no, no.
as far as
So,
civil matters
no,
are
one
concerned,
minute, for our understanding, if they appear, it's not that necessarily they have the copy of memo of appeal. They are not supplied.
the intra-court appeal will not be registered unless copy of it is served on the successful party.
So then,
That is the rule.
yes.
Therefore, it is a service, and after service, the registry numbers the appeal and places before the honorable court.
So that's what the objection here is, that you should file proof of service.
This is the civil proceeding, my lord. Writ proceeding rules do not apply. As far as civil proceedings are concerned, the appellate side rules are different. Their service, my lord, is
So you
actual
are
service.
trying to tell us that this registry is placing this objection by relying on writ proceeding rules which do not apply to this, as it is a civil proceeding, correct?
This is a civil proceeding, is it not? No, as far as CS matters are concerned, my lord,
So those rules do not apply.
they will not apply. The rules
That's what
do
we
not
are
apply.
saying.
Civil procedure code provisions will apply. That is, service is to be effected.
No, but what happens to his objection, Mr.? Now you have taken up his cause, so we will put a query to
No,
you.
I in fact wanted, I was anxious to tell this to my lord, because his civil suits are 1958.
58.
And the addresses of the parties as given in the plaint are not existent today.
No, the office, correct. Office objection in his case is amended cause title in civil suit number so and so for the purposes of verification of cause title since not tallying.
Amended cause title, my lord, is not maintained in CS matters. These four suits are unique, separate, not like other civil suits. The registry, these were suits filed in the district court. They were withdrawn by the High Court for lack of volume of work in 1958. Now, my lord, there is no original filing insofar as this court is concerned, as far as civil suits are concerned. These are the transferred suits from the district courts.
No, in that very civil suit, he has filed an application under Order 22, Rule 10. So whatever his cause title must tally with the proceeding from which it arises. So he doesn't know which proceeding is seeking impleadment, that means. He doesn't know that which OS, if he doesn't know the names of parties, that means we propose that he doesn't know which proceeding is filing under Order 22, Rule 10. What is the basis of his
devolution of interest?
That name parties are made as parties, my lords, but they say because cost title has been subsequently changed, I need to make the new parties as parties. I gave a letter to register lords, my court. I gave a letter to registrar Miller to furnish me the
Sir,
amendment.
your cost title must conform to the amended cost title. Thereafter, just a minute, listen. There is a procedure for everything. Thereafter, you file an application to this court seeking amendment of cost title and saying whatever reasons you are already telling us, and we permit, that's a different case. But it must conform initially to whatever has been mentioned in the cost title of OS 13 of 1958. Thereafter, you may file an application seeking leave to amend for stating X, Y, Z reasons, saying that this is not tallying, address, as senior counsel said, address has changed, whatever. But you cannot, at your will, describe anything as per your convenience, and you tell us not to this thing insist upon it. You are saying that unable to, he is stating not willing to comply, dismissed.
I gave letter.
Whatever he has to vary, with the leave of the court. It's fine, do on his own.
Well, I gave a letter to registrar. Kindly peruse the letter once, my lords. I gave a letter to registrar to furnish me, my lord, to which order copy they have compared it with.
I will, then we will, shall we pass an order?
Sorry.
I like it, so not understanding beyond too much.
I'll comply, my lord.
We are not sitting here to convince you, mister. Please understand, it's your own. We have not moved any order 22 Rule 10. And if you are not, we are not, our job is not to convince you till you get convinced.
No,
sorry.
Sorry,
this is High Court, and we will dismiss your application.
I'll comply, my lords. I'll comply.
The moment we say dismiss, you understand, right? Immediately. And we have been good to you, saying please do it, unable to understand. Perhaps we should, every case we should say, if you don't listen, it is dismissed. Any counsel will immediately, oh, no, sir. Yes, sir, please, what do you want to say? I am ready to listen.
I typed one.
Shall we pass an order?
I'll
It's
complain.
of course open to this thing. You have a right of appeal against our order. Please go ahead.
I'll complain, make appropriate application, I'll complain.
For this,
So not able to complain.
you have wasted how many times you owe all these people who are sitting and watching your performance. We thought that live streaming will improve your performance. Nothing has happened. We are under stress because we have to speak louder and all that, and we are being watched. But we thought that it will improve the performance of judges as well as lawyers. But that side, nothing. See, for this purpose, 28/7, 2 weeks time, despite 5 minutes of sermon and exchange.
I'll complain, I'll make my complaint.
Why you should not have said in the beginning?
Because
Learned counsel for the same order, right? Simple, right? We told you the way out also. He is sitting, he will guide you. We are sure senior counsel will guide you
I'll take.
what to do. 140. You, for whom? 1-2. Learned counsel for
I'm
respondent.
appearing for respondent number 8.
1 to 6 and respondent number 8.
Not served on. I haven't received the copies.
1 to 6 for and are granted. How much time? 4 to 3 weeks time. 3 weeks time to enable him to file counter. Nobody is appearing for petitioner, so we cannot issue any direction. You should understand. So mark his presence. You don't want to file counter. When the copy will be when he will appear, and when he we will ask you to supply your copy. Then you file counter.
I'll obtain the copy.
Better no.
I'll obtain copy.
1 to 6 and 8. Pray for and granted. 3 weeks time. You say none for the petitioner. Again today also right. Then perhaps we can go to this has to be dismissed. What do we say on Dunn had appeared on behalf of the applicants on 4/8/2023. Thereupon, this court had passed the following order. Paragraph. None has appeared even today. It appears that the applicants are not prosecuting interested in prosecuting what? Not interested in prosecuting the application. The same is not interested in prosecuting the application. Accordingly, same is dismissed for want of. Yes. 142. Yes, Mr.
SSR Murthy requested 1 week me. Personal engagement.
Same 4/8/23 he was unwell. We believe that he is well today.
1 week me.
So let's see. What ground today you want an adjournment? What's your name? So we remember you next date. Then you will appear again. You have been engaged to seek an adjournment, right? All the time. Huh? Last time also 4th August you appeared before us and sought for an adjournment. Why do you want an adjournment? At least you have to tell us.
It's personal inconvenience, my lord. Difficulty I'm not.
Mr. So and so. What's your name? Learned counsel. Once again, prays for an adjournment on the ground that arguing counsel, Mr. So and so, is not available on account of personal inconvenience, on account of By way of indulgence, hearing is deferred, list after 2 weeks. One 43.
Maybe this application, Lord, I am permitted.
Same order.
Lord, I am permitted to withdraw with liberty Lord, to pursue, Lord, as and when the application filed by the respondent.
Liberty.
Humble submission, my lordship. I am for
Liberty to do what?
To, Lord, this application is filed, my Lord, seeking direction to the respondents not to entertain any application filed by the unofficial respondents.
So, with the liberty to pursue such remedy as may be available to you in law, correct?
Yes.
Learned counsel.
My lordship.
You are opposing the prayer.
No, my lordship. I am respondent number 1 in this. I just wanted to inform this honorable court. I have filed an objections before this honorable court, my lordship. Kindly peruse.
No.
Yeah.
Mr. You have heard him saying.
I have heard it, my lordship.
So then you want to oppose the prayer?
No, my lordship. But the fact is, I want a clarification from this court.
No clarification. Seek. If you want clarification, file an application.
I do it.
In an application filed by the applicant, which he wants to withdraw, you cannot seek clarification.
Lordship, I have been aggrieved by this application. Just 1 minute, if
Please.
1 minute, my lordship.
Then
he wants to withdraw the application.
Yes.
Before you agree with that,
we asked you.
granted, if you are still aggrieved, you can pass. If
You file an application seeking clarification.
Much of it.
Right? You have not filed any application seeking clarification.
Much of it.
Mark the presence, learned counsel for the applicant seeks leave of this court to withdraw the application with the liberty to take recourse to such remedy as may be available to him in.
Lord, on 144 senior counsel is Lord, short pass over.
What passover, Mr.? No passover.
Or next week, Lord.
No, my lordship. They have been taking time from last 4 times, my lordship. From four
So what? I mean, we should decide it right now and award you the order supply at your residence, right?
My lordship, we have been.
You you are an outstation counsel here or based here only?
Yes, my lordship.
What are you?
No, my lordship. I am here.
Here only.
Yeah, here only, my lordship.
You know this your colleague.
Yes,
you know your colleague.
You know very well. I know him from 20 years.
And you know the counsel who is this thing making on whose behalf.
Yes, my lordship. Last week also they have taken time, my lordship. That is the reason.
We don't understand, but last order sheet at least doesn't indicate so. It records Mr. J. Prabhakar, learned senior counsel, list on 11/8.
Yes, my lordship.
So the order sheet doesn't record that it is adjourned, and I think perhaps
Okay, madam.
all of us have been at the bar.
Yes, my lordship.
And in case of a genuine thing,
Yes, my lordship. Much of it.
not necessary that everything, whatever comes from the other side and from us, have to be opposed as if we are sworn enemies. Nothing of that sort.
Yes, my lord.
We are trying to find a solution to a legal problem within 4 corners of law.
Yes, ma'am.
Your colleague.
Yes, my lord.
You can understand that next date it be taken up or something like that.
Yes, my lordship. I'm ready for that. Much obliged.
Mr. Ask senior counsel to be there.
Yes.
What's your name?
Yes, Krishna.
Again, praise for adjournment on the ground that
Lord, this application is a passing of a final degree, my lord. 124 cents in survey number estimate paid village.
What is the status of OSA 44 of 2002?
Receiver report, me. This court is directed to the appointed new receiver from commissioner to direct the submit the report, me. After filing of the report, the finality may be drawn up. You are awaiting for the report of the receiver, my lord, new receiver. OSA 44.
Awaiting report of the commissioner. Hearing is deferred. List after 4 weeks. The same. Which order? Put it like ulta. Yes. None for the petitioner. Awaiting report of the commissioner. Hearing is deferred. List after 4 weeks. Yes.
Yes, but I'm appearing for respondent.
In the application filed under 21 rule 97 that to remove the obstructions by the respondent.
Report of the commissioner awaited or filed.
We have not read, sir.
Filed.
14 matters, report of the commission is awaited, madam.
Awaited. Will that defer? Awaiting report by the commissioner.
In fact, report was already filed in respect of this property. Final decrees are passed. It is under order 21. Blood. Only one property is blood left over without filing report.
So new commissioners have been appointed.
Yes,
You don't know.
Yes.
Huh? Then why should you say that?
Let them file.
Same order awaited. 4 weeks. Same order. Yes. 4 weeks.
149 up to blood 151 are connected to 147.
149,
149
connected matters.
150, 151 are connected to 147.
Whatever order has been passed, in what order? Report 147, what order have you passed?
Blood, await report 4 weeks.
Same order in 149, 150, 151.
Awaiting for the report.
Same order. Await commissioner's report list after 4 weeks.
Same minutes, awaiting report.
Same order 153.
Published.
Report of the commission is awaited, madam. Report of the commission
In
is
this
3 matters.
I appear for the respondent, writ petitioner, Advocate General's appeal, Mallet. State has filed this writ appeal. Mallet, the background is this, Mallet. I am a purchaser of a parcel of land from a person who has got it under
No, but
CS.
this is come on suspension, implead, IA. It has come up on orders on IA under interlocutory.
I'm appealing.
2 applications for impleading and suspension are pending.
No, impleading application, Mallet, is being opposed. Suspension is the suspension of the learned single judge judgment itself.
So what
There has been a suspension, Mallet, on the day when it is admitted in 2016.
Right. So we can dispose of this IA 1 of 16, or you want to argue?
No, I would like to argue, Mallet. I just tell to kindly give me only 2 minutes, Mallet.
Yes, sir. Please.
My vendors have got this particular parcel of 24 acres of land in CS number 14. That is my sin not today. And I have purchased them just under a registered sale deed and thereafter applied for mutation under the.
They have got it, your vendors got it.
My
under-
vendors got it in CS number 14 of 1958.
How?
And because of a final decree passed there. Well, that is not the issue in the present case.
No, you said that they got it in CS 14 or 58.
Yes.
We are just asking how they have got it in CS 15.
In a final decree proceeding passed in CS 14. Then I have purchased from them. The short point is this, Palit. After purchasing under registered sale deed, I applied for mutation under the record of rights.
What registered sale deed? Dated? Registered sale deed?
Sale deed dated 10/6/2005. 10th of June 2005.
Yes.
Then on the basis of this sale deed, I have applied for mutation under the AP Record of Rights in Land and Patadar Passbook Act 1971, for short the ROR Act. The state authorities have granted mutation in my favor. And that mutation is subsisting. And after the mutation, on the basis of mutation, I have requested the state authorities to disclose my name in the Pahani Patrika. I gave a legal notice before approaching this court. The state is disclosing this particular survey number 77 of Hafizpet village as government land. Under this act, 1971 Act, the Act does not apply under section 12 to government lands at all. And then learned single judge allowed my writ petition. Learned single.
In which district?
Hafizpet comes in Rangareddy.
Yes,
which you said Hafizpet village and something you said.
Hafizpet village is the village in which this land is.
Where is that village? Which district?
That is in Rangareddy district.
Okay.
Seri Lingampalli Mandal, Rangareddy district.
Okay.
And after the mutation has been granted to me, which is subsisting, since my names are not, my name is not reflected in the Ani Patrikas, which are revenue records under the same act, I have approached this Honorable Court. So long as the mutation is subsisting, the non-disclosure of the name of the writ petitioner in the Pahani Patrikas is arbitrary. Learned single judge accepted the contention, allowed the writ petition. Then against that, state authorities have preferred this writ appeal. This implead party petitioners are coming now for the first time in the writ appeal, saying that they have also got a claim over this particular parcel of land. They do not have any document or any final decree. That is not the subject matter of the present writ appeal. It is the state's appeal. How the learned single judge has
got it. Yes.
Lordship, I'm appearing for the petitioner on behalf.
No, if you want anything, madam, file a petition. If you are owner, do whatever you want to. In this writ appeal filed by the state, we are not going to declare that you have title in respect of land and all this.
Lordship,
Application under Order 1 Rule 10 for impediment can be filed. It can't be filed to enhance the scope. It doesn't provide a remedy, nothing. There is an order subsisting in his favor. The state is aggrieved by it. We will decide what is to be done. But your claim can't be entertained, correct? We are sure about it.
you let me permit to speak on this. Your Lordship, in the
Of course, but don't feel that we are not permitting. Take the mic. But we thought that anybody will understand what is the scope of Order 1 Rule 10. You must have read. No, not read.
No. Lordship. In the
Alright.
petition itself, we have filed an incomplete petition that was not considered by the lower court.
Learned single judge rejected it.
Madam, this is not lower court and all that. That shows your inexperience. When have you joined, madam?
Your Lordship,
When have you joined?
I am a very recent joining. Your Lordship.
That's why lower court saying single judge of this court in a division bench before division bench is lower court.
I'm sorry, Your Lordship. Actually,
You should be, madam.
Your Lordship,
We cannot permit the dignity of this court to be brought down in the manner for your inexperience, and we will impose cost on you for saying, addressing learned single judge as lower court.
my apologies, Your Lordship. Actually, I wanted to submit that this matter has been represented by the senior counsel.
Nothing, no senior counsel.
Lordship, due to personal inconvenience, senior counsel cannot attend to this matter. I wanted to start with that, Your Lordship. I was seeking an adjournment in this matter, Your Lordship.
You can appreciate her predicament, right? Mr. Senior Counsel, we have this, we are clear about what you have argued. We will record this. And don't come, madam, to this court, right? If you come only when you want to argue the matter, don't let like a postman thing, postwoman thing, he is unwell. There's no need. It's our case. We have taken note to do justice. We will do it in accordance with law. This, you have assured us, no, each one of us, that bar will extend full cooperation. This is the cooperation. That every time when it is called, you stand up with this. Nothing in this case. You better think about it, Mr. Except the subject matter of civil suit 14, you better think about it. How do you assail? Merits. We will hear you on merits. You are saved by her. Otherwise, we would have asked.
May I submit the copies of the order for the Honorable Court, my lords?
Huh?
Yes. As on today, my lord, there is no final decree, my lords. For trying a final decree.
No, argue on merits. We understand your standard argument, subject matter of civil suit 14 of 1958. This is what we know, Mr. by now. Each one of you have started knowing. What will you argue? We can anticipate.
My lords, sir, please to
That's why we are saying, argue on merits of the matter. How do you assail the order passed by the learned single judge? Have you cancelled this patta granted to him?
My lords.
Right? And if he is what passbook is standing, how can you, and whether entry in the revenue records confers any title on any person, right?
My lords, Honorable Supreme Court, my lord, recently while adjudicating the Hyder Nagar issue, my lords.
No, Mr. We are putting you on notice. You say I will examine. Don't argue right away.
Yes.
You know that she is seeking adjournment, and we can decide her application right away, but she will be in trouble.
Yes.
Her senior will say that you are not good enough even to seek an adjournment. What will happen? She is just joined the profession back. That's why we are adjourning.
Yes.
Her predicament, right? Mark the presence. Learned senior.